Senator Pate.
Thank you, Mr. Speaker. Honourable Senators, I rise today to speak to Bill C-5. I thank Senator Gold for his able sponsorship of this bill. Regrettably, as written, Bill C-5 will not even come close to realizing the objectives outlined by Senator Gold. The good news, though, Honourable Senators, is that we have the opportunity to fix that. Indeed, as Senators, we have the responsibility to amend this bill, return discretion to judges, and thus help to guard against unjust and ineffective sentencing. Bill C-5 rightly acknowledges that mandatory minimum penalties result in unfair sentences, in particular for members of racialized groups. Yet it only seeks to repeal 20 mandatory minimum penalties. Not only is this less than a third of the mandatory minimum penalties currently on the books, the bill covers only a fraction, 10 of 44 mandatory minimums already struck down as unconstitutional and as cruel and unusual punishment by courts in different provinces and territories. Bill C-5 will not achieve the government goal of reducing the number of federally imprisoned Black or Indigenous people, most especially not Indigenous women. By repealing only some mandatory minimum penalties, the government falls far short of its commitment to reconciliation and the implementation of the calls to action of the Truth and Reconciliation Commission. Having promised the Canadian public it would go further, the government now claims that Bill C-5 is the best they can do at this time. But is it? I don't think so. The evidence remains incontrovertible that mandatory minimum penalties create and perpetuate inequality and mass incarceration. The government says they cannot do more at this time, but they have provided no follow-up plan or clear next step toward fulfilling their promises to the electorate. The government has provided no, as in zero, rationale for its piecemeal approach to eliminating mandatory minimum penalties for some offences, but not others, and leaving in place a patchwork of inconsistent sentences throughout this country. Bill C-5 reflects the government's fear of being labelled, wait for it, soft on crime. Fear that some people may mischaracterize the removal of some MMPs as leniency or even full decriminalization, rather than the reality that it merely allows judges to do their job to impose fair sentences in some, but still not all, let alone most cases. In 1952, the Royal Commission on the Revision of the Criminal Code concluded that all mandatory minimum sentences should be abolished. For 7 decades, umpteen experts have advocated for the repeal of mandatory minimums. The TRC, the Missing and Murdered Indigenous Women and Girls Inquiry, every Law and Sentencing Reform Commission, the Supreme Court of Canada, as well as our own Senate Legal and Human Rights committees have recommended remedying the wrongs of mandatory minimum penalties. A 2017 Department of Justice survey reported that 9 out of 10 Canadians support the government ensuring judges have the flexibility to not impose mandatory minimum penalties. In the 1999 Gladue decision, the Supreme Court of Canada declared the overrepresentation of Indigenous peoples in prisons a national crisis. At the time, Indigenous people represented 10.6% of the country's federal prison population. Today, they are 32%. If it was a crisis in 1999, my friends, what on earth is it now? I say it is a shameful catastrophe that we must prevent from growing worse. This is most especially true when we talk about Black and Indigenous women. When I joined this chamber 6 years ago, today, Indigenous women represented some 32% of the federal prison population. This year, Indigenous women make up half of all women in federal prisons, and 1 in 10 of federally sentenced women are Black. As it currently reads, Bill C-5 will most certainly contribute to increased criminalization and imprisonment, most definitely of Indigenous and Black women, as well as increased seizure of their children by child welfare authorities. The MMIWG inquiry underscored that the issues that give rise to Indigenous women being more likely to go missing, be disappeared, murdered, or be rendered homeless and impoverished are the same conditions that cause them to be the fastest growing prison population in this country. Namely, 50% of the women serving sentences of 2 or more years, more than 75% of women serving sentences of under 2 years in most of the western provinces, and in Saskatchewan and Manitoba in the north, 95 to 100% of the young women and girls in youth jails are Indigenous. Most are first or second generation residential school survivors, have experienced the trauma of sexual and physical abuse, child welfare involvement, and disabling mental health issues. We are tasked with representing the interests of the most marginalized. In this case, colleagues, Indigenous and Black people are relying on us to not continue to relegate them to prison and their children to state care. We owe them our best efforts to stem this tide. Colleagues, let's do what is right. The majority of the expert witnesses who appeared before the legal committee explicitly advocated for the elimination of all mandatory minimum penalties, or at the very least, that we amend Bill C-5 in order to allow judges to not impose mandatory minimum penalties that the bill does not repeal. Why? Because mandatory minimum sentences are a primary contributor to overrepresentation of Indigenous and Black people in prison. They preclude judges from weighing all the evidence and then exercising their discretion to impose the fit and proper sentence. They prevent judges applying what are often referred to as Gladue factors. These Section 718(2)E sentencing provisions of the Criminal Code of Canada direct judges to limit the use of incarceration and to consider factors crucial to ensuring sentencing fairness. MMPs go against the very heart of sentencing principles. Without amendment, Bill C-5 will not even put a dent, not a dent, in the over-incarceration of Indigenous and Black people, both because it applies to so few offenses and because, as witnesses before the committee underscored, the government's own data shows this bill will add jet fuel, my friends, to discriminatory charging and prosecutorial practices. It will magnify, replicate, and reinforce discrimination. The existence of mandatory minimum penalties drives up the average length of sentence for all criminal convictions. They also induce Crown prosecutors and defense counsel alike to plea bargain. Too many people charged with an offense that carries a mandatory minimum penalty are encouraged to plead guilty to lesser offenses rather than face the uncertainty of a trial with the risk of a mandatory minimum sentence, regardless of whether they are guilty or, more importantly, if they are not. Similarly, too often abused women who, after long and horrific histories of abuse, act to defend themselves or those in their care may use a weapon. If their reactions to serious threats and violence result in serious harm to their abuser, they will usually be charged with the commission of a violent offense, precluded from C-5. If the person dies, they will most often be charged with murder, which carries a mandatory minimum sentence of life imprisonment. Even when they may have acted in self-defense or defense of their children or others, the incentive to plead guilty to manslaughter to avoid the risk of a mandatory life sentence is overwhelming for most women in this tenuous situation. Many such women are Indigenous, yet this bill would not allow judges to appropriately examine the circumstances of each of such cases and tailor a sentence accordingly. In their recent decisions in Bissonnette, Ndlovu, and Sharma, the Supreme Court of Canada reinforced that Parliament has an obligation to address the appropriateness of penalties and should not be leaving the current piecemeal approach to sentencing reform to the courts. In 2015, Prime Minister Trudeau promised the world, quote, in partnership with Indigenous communities, the provinces, the territories, and other vital partners, fully implement the calls to action of the TRC, starting with the implementation of the United Nations Declaration on the Rights of Indigenous Peoples, end quote. He tasked the Minister of Justice with decreasing the number of Indigenous people in prison, and every minister's mandate letter includes a commitment to reconciliation and implementing the UN Declaration. More recently, including at the UN and the second National Day for Truth and Reconciliation, The Prime Minister reiterated his commitment and said he was, quote, hugely impatient to do even more, end quote. Me too. Bill C-5 ignores the TRC calls to actions 30 and 32 and calls for Justice 5.14 and 5.21 of the Missing and Murdered Indigenous Women and Girls Inquiry that focus on repealing all mandatory minimum penalties and redressing the current overrepresentation in prisons of Indigenous people, most particularly Indigenous women. Many Indigenous and Black leaders, including just today, the Assembly of First Nations National Chief Archibald, called on us to heed the advice of our former colleague, the Honourable Murray Sinclair, and deal with this crisis now. We have already sentenced those waiting for this change to further catastrophe. We need to act to allow judges to do their jobs and free them from the limitations MMPs currently place on their ability to weigh all of the circumstances and determine appropriate sentences. The government claims that any amendment would effectively kill the bill. We have heard this before. They said that when the Senate insisted on maintaining women's reproductive rights. Also when the Senate added Section 718(2)(e) to the sentencing principles of the Youth Criminal Justice Act. They said the same when we insisted on the removal of gender inequality in Bill S3 amendments to the Indian Act. The list goes on, colleagues. In these cases, not only was the threat untrue, but the Senate amendments vastly improved the flawed legislation. The Senate must learn from the lessons of the past and not repeat mistakes. Let's learn from our history of institutionalizing the most marginalized. Let's rely on the evidence and not allow MMPs and the resulting mass incarceration and consequent state removal of children to be our institutional legacy. Colleagues, we have a catastrophe on our hands. We have allowed this to happen, like residential schools, unmarked graves, and the crisis of missing and murdered Indigenous women and girls. We know that our laws and policies are perpetuating and perpetrating injustices. Knowing this, we have a choice. We can continue to hide our heads in the sand, or we can act. We can decide to fix Bill C-5 to try to remedy the wrongs, achieve the purpose the government set for it, and stem the tide of the most egregious harms. Colleagues, those we serve need our courage now more than ever. It is our responsibility not to fail them. Miigwech, merci. Thank you.